Mr. Long, there's another argument that has been made that I would like you to address, and that is all this talk about tax penalty. It's all beside the point because this suit is not challenging the penalty. This is a suit that is challenging the must-buy provision. And the argument is made that if indeed must-buy is constitutional, then these complainants will not resist the penalty. So what they're seeking is a determination that the must-buy requirement, stated separately from the penalty, that must-buy is unconstitutional. And if that's so, that's the end of the case. If it's not so, they're not resisting the penalty.
Well, I think that argument doesn't work for two reasons. I mean, first, if you look at the plaintiff's own complaint, they clearly challenge both the minimum coverage requirement and the penalty. At page 122 of the joint appendix, they challenge the requirement that the individuals obtain health care coverage or pay a penalty.
But why does that? If that's the problem, it's easy to amend a complaint. You can just take that out of the complaint, so it can't turn on.
Well, and yes, I mean, it's or another complaint would be filed, but still, I think that's a serious problem. But even if they had filed a different complaint, I don't think in this case, I don't think you can separate the minimum coverage requirement from the penalty, because the penalty is the sole means of enforcing the minimum coverage requirement. So first, I mean, I think these plaintiffs would not be satisfied if the court were to render a judgment saying the minimum coverage requirement is invalidated. The penalty, however, remains standing. Anybody who doesn't have insurance has to pay the penalty. Then they'd have to pay a penalty equal to the cost of insurance, and they wouldn't even have insurance. So I don't think that would be.
Well, they say they want to obey the law, and they say that your argument puts them in the position of having to disobey the law in order to obtain review of their claim. And what is your answer to that?
Well, I mean, first of all, I can't find that in the record, in their declarations. I don't see a statement that they will, never incur a penalty under any circumstances. But even if that were so, what this court has said in Americans United is the Anti-Injunction Act bars any suit not just to enjoin the collection of your own taxes, but to enjoin the collection of anyone's taxes. And so even if it were really true that these plaintiffs were not interested in the penalty and would never pay the penalty, if they were to succeed in this case in striking down the minimum coverage requirement, the inevitable result would be that the penalty would fall as well, because the government couldn't collect a penalty for failing to follow an unconstitutional requirement. And so it would still be barred because it would be a suit that would prevent the collection of some.
Well, that may take us back to Justice Kennedy's question about the for the purpose of language. I take it you interpret the statute to mean the following. For the purpose of means having the effect of. Is that correct?
Well, I mean, this court in the Bob Jones case, where a similar kind of argument was being made by the plaintiff in that case, said, look, where it's inevitable that this is what the suit is about, there's sort of two sides of the same coin, that clearly is a primary purpose of the suit, and you can't, by clever pleading, get away from that. That's just the nature of the situation.
But, Mr. Long, aren't you trying to rewrite the statute in a way? The statute has two sections. One is the you have to have insurance section, and the other is the sanction. The statute has two different sets of exceptions corresponding to those two different sections. You're trying to suggest that the statute says, well, it's your choice, either buy insurance or pay a penalty or pay a fee. But that's not the way the statute reads, and Congress, it must be supposed, made a decision that shouldn't be the way the statute reads, that it should instead be a regulatory command and a penalty attached to that command.
Well, I would not argue that this statute is a perfect model of clarity, but I do think the most reasonable way to read the entire statute is that it does impose a single obligation to pay a penalty if you are an applicable individual and you're not subject to an exemption. And the reason I say that, if you look at the exemptions from the penalty, I mean, the very first one is you're exempt from the penalty because you can't afford to purchase insurance. And it just doesn't seem reasonable to me to interpret the statute as Congress having said, well, this person is exempt from paying a penalty because we find they can't afford to buy insurance. However, they still have a legal obligation to buy insurance. That just doesn't seem reasonable. So I do think, although I certainly wouldn't argue it's clear, that that's the best way to understand the statute as a whole. But again, I would say, that's not essential to the question we're discussing now of whether the Anti-Injunction Act applies. Again, I think...
Could you tell me why you think the Solicitor General's reading creates a problem?
Well, and going back to, so if the result were to say simply this is not, the Solicitor General's reading. So now it's not...
that it is a jurisdictional bar, but there's an exemption for those items that Congress has designated solely as penalties that are not like taxes.
Right. Well, I think the Solicitor General's reading would probably create the fewest problems, as I understand it. My main objection to the Solicitor General's reading is I don't think it makes a whole lot of sense. Basically, the Solicitor General says every penalty in the Internal Revenue Code, every other penalty in the Affordable Care Act.
That's carrying it too far, because he says if a penalty is designated as a tax by Congress, then it's subject to the AIA, and that's most of the code, the tax code. And he says for those portions of the Affordable Care Act that designate things as taxes, the AIA applies. So it's only, and I haven't found another statute, I'm going to ask him if there's another one. It's only for those statutes in which Congress has designated something solely as a penalty,
right,
and not indicated that it's a tax,
right,
they don't fall within the AIA.
I think my take on it is if you adopted the Solicitor General's approach, there are probably 3 penalties for alcohol and tobacco-related offenses, 5114C, 5684, and 5761, that I think would be very difficult to distinguish from this one, and possibly the 527J penalty for failure to disclose political contributions. If there are no further questions, I'd like to...
Thank you, Mr. Long. General Verrilli.
Mr. Chief Justice, and may it please the Court, this case presents issues of great moment, and the Anti-Injunction Act does not bar the Court's consideration of those issues. That is so even though the Anti-Injunction Act is a jurisdictional limit that serves what this Court described in Clintwood-Elkhorn as an exceedingly strong interest in protecting the financial stability of the federal government, and even though the minimum coverage provision of the Affordable Care Act is an exercise of Congress's taxing power as well as its commerce power. Congress has authority under the taxing power to enact a measure not labeled as a tax, and it did so when it put Section 5000A into the Internal Revenue Code. But for purposes of the Anti-Injunction Act, the precise language Congress used is determinative, and there is no language in the Anti-Injunction Act, no language in Section 5000A of the Affordable Care Act or in the Internal Revenue Code generally that provides a textual instruction that...
General Verrilli, today you're arguing that the penalty is not a tax. Tomorrow you're going to be back and you'll be arguing that the penalty is a tax. Has the Court ever held that something that is a tax for purposes of the taxing power under the Constitution is not a tax under the Anti-Injunction Act?
No, Justice Alito, but the Court has held in the licensed tax cases that something can be a constitutional exercise of the taxing power, whether or not it is called a tax. And that's because the nature of the inquiry that we will conduct tomorrow is different from the nature of the inquiry that we will conduct today. Tomorrow, the question is whether Congress has the authority under the taxing power to enact it, and the form of words doesn't have a dispositive effect on that analysis. Today, we're construing statutory text where the precise choice of words does have a dispositive effect on the analysis.
Well, General, you also have the Bailey child labor tax cases, because there the court said that the tax, which was a prohibitory tax alone, was a tax subject to the AIA, and then said it was beyond the court's taxing power in a separate case, correct?
Yes, I do think, Justice Sotomayor, that with respect to one of the arguments that my friend from the NFIB has made in the brief, that Bailey against George is a significant problem, because I think their argument on the constitutionality under the taxing power is essentially that the Affordable Care Act provision is the same thing as the provision that was held unconstitutional in Bailey against Drexel Furniture. But on the same day, but on the same day as Bailey against Drexel Furniture, the court issued Bailey against George, which held that the Anti-Injunction Act did bar a challenge to that provision, even though the court had concluded that it was invalid under the tax power. So, I think the reason for that is clear now after Williams Packing and Bob Jones, in that in order to find that the Anti-Injunction Act doesn't apply to something that otherwise would be a tax that triggers it, you have to conclude essentially that there's no substantial argument that can be made in defense of it as a tax. We don't have that here, so I don't think you can get around the Anti-Injunction Act if the court were to read it as the amicus suggested should be read on that theory.
Mr. Varelli, a basic question about your argument. If you're right about the second part, that is, for purposes of the statute, the anti-injunction statute, this penalty does not constitute a tax, then does the court need to decide whether the Anti-Injunction Act in other cases where it does involve a tax is jurisdictional?
No. I apologize if I'm creating any confusion about that, Justice Ginsburg. We think by far the better route here is to understand the statute as we have proposed that it be construed as not applying here. From the perspective of the United States, and if I could, I'd like to take a minute on this, the idea that the Anti-Injunction Act would be construed as not being a jurisdictional provision is very troubling, and we don't think it's correct. And I would, if I could, follow up on a question, Justice Ginsburg, that you asked Mr. Long in terms of the language of the Anti-Injunction Act 7421A, which can be found at page 16A of the appendix to our brief. I'd ask the Court to compare that to the language of the very next provision in the Code, which is on the next page of our statutory appendix, 17A, which is the refund statute, which we've talked about a little bit so far this morning, 7422A. The refund statute this Court held in Dolm was jurisdictional, and the Court in both Dolm and Brokamp held that the statute of limitations that applies to refund statute cases is jurisdictional. The language in 7422A is virtually identical to the language in 7421.
That is correct, although in the refund context you have the sovereign immunity problem in which we presume that has not been waived.
Right, but 7421
you're
7422
the language
were the same,
parallel.
and originally they were the same statutory provision. They were only separated out later. So I do think that's the strongest textual indication, Justice Ginsburg, that